much, Chairman and Senator Grassley. Welcome again, Judge, your wonderful family. They all seem to be awake throughout this entire hearing. I just wanted to, before I start, get at something Senator Lee was talking about. It's not the Dormant Commerce Clause, but I really appreciated early on how you talked about these child pornography cases. A former prosecutor could totally see where you were coming from when you talked about looking at these cases as a mom and a judge. And would it surprise you at all that other judges, including a number of them that were supported by our colleagues on the other side of the aisle, have given out similar sentences in child pornography cases?
No, Senator, it would not surprise me because these cases are horrific, and there's a lot of disparity because of the way the guidelines are operating in this particular area. But in every case that I handled involving these terrible crimes, I looked at the law and the facts. I made sure that the victims, the children's perspectives were represented. And I also imposed prison terms and significant supervision and other restrictions on these defendants.
Well, thank you. And I just also want to note, and I know others have brought this up, the letter of support from the Fraternal Order of Police, in which they said, from our analysis of Judge Jackson's record and some of her cases, we believe she has considered the facts and applied the law consistently and fairly on a range of issues. There is little doubt that she has the temperament, intellect, legal experience, and family background to have earned this appointment. We are reassured that should she be confirmed, she would approach her future cases with an open mind and treat issues related to law enforcement fairly and justly, and that matters a lot to many of us. Now, I want to go back to something I was talking about yesterday, and that is why today's hearing is so monumental, including that it is occurring at a time when we as Americans have been reminded again, due to the courage of Ukrainians thousands of miles away, that we can never take our democracy, or for that matter, our courts for granted. It is also happening at a time when we are seeing each other for the first time after a 2-year pandemic, connecting to each other again. And I hope this moment will be a moment where we see a renewed interest in our democracy, that we respect each other's rights and views, and that we see that we are not a nation of 300+ million silos. Instead, we are a nation committed to this idea that what unites us as Americans is much bigger than what divides us. And so in that context, you come before us with this incredible strength, legal acumen, grace under pressure that you have demonstrated today. And you also come before us, as we've noted, as the first Black woman to be nominated following 115 justices who have been confirmed. And I will note, of the 115 justices, 110 have been men. And I actually once reminded a late-night show, Trevor Noah, of similar issues in the U.S. Senate. In fact, in the history of the U.S. Senate, of the nearly 2,000 people who have served, only 58 have been women. And he responded that if a nightclub had numbers that bad, they'd shut it down. But today, Judge, we're not shutting anything down, not the court, not the Senate, and you are opening things up. And I think one of the things your nomination presents is an opportunity to address a decline in the public's confidence in our court. And increasingly many, if you see public opinion polls, see the court as over-politicized or out of touch. At the same time, we've seen an alarming rise in threats targeting members of our judiciary for just doing their jobs. How do you think we can work to maintain the public's confidence in the court? What do you see your role in that?
Thank you, Senator. Public confidence in the court is crucial. As has been said here earlier, the court doesn't have anything else, that is the key to our legitimacy in our democratic system. And I am honored to accept the president's nomination in part because I know it means so much to so many people. It means a lot to me. I am here standing on the shoulders of generations of Americans who never had anything close to this kind of opportunity. From my grandparents, who had just a grade school education, but instilled in my parents the importance of learning. And my parents, who I've mentioned here many times already, who were the first in their families to get to go to college. So this nomination, against that backdrop, is significant to a lot of people. And I hope that it will bring confidence. It will help inspire people to understand that our courts are like them, that our judges are like them, doing the work, being a part of our government. I think it's very important.
Very good. I think along those lines, your wonderful mentor, Justice Breyer, I quoted him about how he said, we can help maintain public acceptance of the court, and these are his words. We can do it best by helping ensure that the Constitution remains workable in a broad sense of the term. Specifically, the court can and should interpret the Constitution in a way that works for the people of the day. Like, as you know, it's, I think, Article 2, Section 2 doesn't refer to the Air Force because we didn't have an Air Force back then. So are there things about the Constitution that, of course, as we've gone along, have been interpreted to meet the moments of our time? What do you think Justice Breyer means when he says the Constitution should be interpreted in a way that works for the people of today? And do you think a justice can be both pragmatic and objective and respect history?
I do, and I think that the justices have demonstrated that. Some of their recent opinions have had to deal with modern technologies that did not exist at the time of the founding. So, for example, the Riley case, the Carpenter case, these were Fourth Amendment decisions in which the court was asked to determine whether or not it violated the Fourth Amendment for the police to search someone's cell phone without a warrant, or for the police to use GPS location data to determine where someone had been without a warrant. And obviously, those technologies did not exist. But what the court did was it looked back at the time of the founding and determined what the reasonable expectations of privacy were related to the term unreasonable searches and seizures, which appears in the Constitution. And having assessed what that meant back then, they could use those principles to decide whether or not a cell phone is like someone's home these days, with all of the information and all of the things that are stored there. And the court determined that it was a violation of the Fourth Amendment, that the police officers needed a warrant, and they did so with reference to what the Constitution meant in history.
Mm-hmm. Very good. You know, you were viewed as a judge, and you talked about this a bit yesterday, that writes lengthy opinions, that believes you should spell things out, and believes in being transparent. Is that a fair characterization? I don't
That is.
Okay, good. I'm sure your clerks know that. I want to talk about something to me that's a bit the opposite, and that's something that some have termed the shadow docket. And that includes decisions that the court makes on an expedited basis that are usually unsigned and issued without oral argument or full briefing. In the last few years, we've seen the court increasingly deciding cases in this way, often over the dissent of maybe 3 or 4 of the justices. Last term, the court granted 20 requests for emergency relief, a historically high number. 10 years ago, in the October term of 2011, the court granted only 6 requests in an entire year. When do you think it's appropriate for the Supreme Court to grant emergency relief, use this docket? When are the circumstances that warrant this? And I think you know these decisions have a profound effect on people's lives. I'll just use one example. Last fall, in a 1-paragraph decision, a majority of the court refused to stop the enforcement of a Texas law that severely restricts a woman's access to abortion. In that case, even Chief Justice Roberts objected to the court's decision to let the law take effect, calling the statutory scheme not only unusual but unprecedented. As someone who believes in transparency, could you talk in general about when you think this shadow docket should be used, when emergency relief should be given, and how, if it's overused, it could undermine public confidence in the court?
Thank you, Senator. Well, there's a balance that the court has to consider, and that it, insofar as, on the one hand, it has always had an emergency docket, the need for flexibility, the ability to get answers to the parties at issue is something that's important in our system. On the other hand, the court has also considered the interest in allowing issues to percolate, allowing other courts to rule on things before they come to the court. And I am not privy at the moment to the justices' views and why and how they're using the emergency docket in these cases. If I was fortunate enough to be confirmed, I would look at those issues. But it's an interesting and important set of issues.
Okay. I think just another example of this, by the way, is the day before Wisconsin's primary election on April 6, 2020, right as the first beginnings of some of the health orders that came out with the beginning of the pandemic. The court issued a 5-4 decision halting a district court's order allowing voters extra time to cast their absentee ballots so that they could avoid waiting in line to vote. And back then, people literally got COVID with election workers and the like because of this. And again, I'm not going to belabor this point, but I think some of this is these decisions that are made that don't reflect some of the careful consideration that you have made in many of your decisions as a judge. But speaking of voting, I'll ask you one question on that front. Since the Supreme Court gutted the Section 5 preclearance regime of the Voting Rights Act in its decision in Shelby County, the D.C. Circuit has not seen many voting rights cases. However, as you know, Justice Ginsburg dissented in that case, describing the right to vote as the most fundamental right in our democratic system. Do you agree that the right to vote is fundamental?
Senator, the Supreme Court has said that the right to vote is the basis of our democracy, that it is the right upon which all other rights are essentially founded, because in a democracy there is one person, one vote, and there are constitutional amendments that relate directly to the right to vote. So it is a fundamental right in our democracy.
Yes, I know that's how Justice Barrett answered that question as well in her recent hearing. I'm going to turn to an area that Senator Lee and I, we both chair the subcommittee on antitrust, and so it's near and dear to my heart. So I thought I'd spend a little time. It usually gets relegated to the second round, but I'm putting it up on the docket here. U.S. antitrust law has been described as a comprehensive charter of economic liberty, and I agree. And effective antitrust enforcement plays a critical role, as you know, in protecting consumers and workers, promoting innovation, ensuring new businesses have an opportunity to compete. It actually, from really early on in our country's history, has been a very important part of assuring that capitalism works. And in January, for the first time since the dawn of the internet, the Senate passed a tech competition bill out of the Judiciary Committee. It's a bill that Senator Grassley and I lead. Many of the members of this committee supported the bill, 16-6 vote. It's called the American Innovation and Choice Online Act. It's now headed to the Senate floor. I'm not going to ask you about that bill, obviously, but I want to put this in some context. While tech monopolies have seized from 50 to 90% market share in major parts of their business lines, it is clear to me when you look at the plain language of the Sherman Act, Clayton Act, laws that are in place, that these monopolies are not okay. However, court rulings for decades in antitrust have created some major obstacles to taking on these cases. And it's not just court rulings. It is on us with, as I said, the dawn of the internet, decades having passed. It is on us, this Senate and the House, to update our laws this year to give enforcers the resources to do their jobs, something you, if confirmed, would not have a role in. But the role of the courts is also very critical. You have been nominated to replace Justice Breyer, who came to the court with a strong background in antitrust law. I know you handled a case. You and I discussed it in my office. I think it got decided the merger was abandoned, so you didn't have to rule on the merits of it. It was back in 2017, a FTC challenge. But I'll just quote something that Justice Breyer once said. He told this committee, if you're going to have a free enterprise economy, then you must have a strong and effective antitrust law. Do you agree with Justice Breyer's statement, and how would you characterize the goals of our antitrust laws?
Well, thank you, Senator. The antitrust laws protect competition and, as you said, therefore protect consumers and competitors and the economy as a whole. And the Sherman Act and the Clayton Act are broad in their in their statements, in their protections, and there's a lot of precedent in this area. If I were confirmed, I would use my methodology to look at the precedents in these areas to ensure that any legislation that I was considering is interpreted according to the text, consistent with Congress's intent. And in the area of antitrust, that is ensuring that there is consumer protections.
Mm-hmm. Very good. And just to play it out a little bit, since the 1980s, the court in cases like Trinco and Credit Suisse, Ohio v. American Express, has really made it increasingly difficult to enforce the antitrust laws and protect competition. And during that same time, and I know many of my colleagues know this, we have seen a rise in industry consolidation, market power, not only in tech with companies like Google and Amazon and Facebook and Apple, but also across our economy, really in everything from pharma to cat food to caskets. What role do you think that congressional intent should play in the court's interpretation of the antitrust laws? And I say that because I think that we're dealing with some cases where justices have actually substituted their own ideologies for the intent of Congress in originally passing the laws. And I think it was Justice Souter who once said before this committee, when we are dealing with antitrust laws, we are dealing with one of the most spectacular examples of delegation to the judiciary that our legal system knows. And he added this: certainly a respect for legislative intent has got to be our anchor for interpretation. So what role do you think congressional intent should play in the court's interpretation of the antitrust laws?
Thank you, Senator. So I've interpreted a number of statutes in my near decade on the bench. And in every case, the text of a statute is what the court looks at in order to ascertain what the legislature intended. And that is important because, as I've said, courts are not policymakers, and judges should not be importing their own policy preferences. Judges are restrained in our constitutional scheme in order to affect the will of Congress in terms of their interpretation of the laws.
Okay, thank you. I'm going to turn to another topic, and that's freedom of the press, New York Times v. Sullivan, 1964 case. We have recently witnessed, as you know, unprecedented attacks on journalists and journalism, whether it's violence overseas, recently losing, sadly, members of the press just in the last month in Ukraine, or threats and intimidation at home. This is very concerning to me, given the important role of the First Amendment. My dad was a newspaper reporter, so the issues hit home for me. Can you talk about your view of the role of journalists in our democracy?
Thank you, Senator. Journalists, freedom of the press is protected by the First Amendment. It is about the dissemination of information, which is necessary for a democratic form of government. The Supreme Court has held as much, and that was the basis for the court's determinations in protecting the press from liability in New York Times versus Sullivan and its progeny.
Okay. As you know, that ruling was a unanimous ruling in support of the First Amendment, and the court held that when newspapers report on public officials, they're only liable for untrue statements that are published with knowledge or reckless disregard for whether the statement was false. The court in Sullivan based its decision on our country's, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. That's their quote. And it recognized that, quote, erroneous statement is inevitable in free debate, end quote, must be protected if the freedoms of expression are to have the breathing space that they need to survive. Do you agree that those principles are just as relevant today as they were when the Supreme Court first decided New York Times v. Sullivan?
New York Times v. Sullivan is the continuing binding precedent of the Supreme Court, and it does state the principles that the court has determined are undergirding the First Amendment right to free press.
Okay. And last summer, actually, in Berisha v. Lawson, the Supreme Court declined to review a case in which the 11th Circuit applied New York Times v. Sullivan. Justice Thomas and Justice Gorsuch each dissented from the decision not to grant cert, arguing that the court should reconsider its holding in Sullivan. How would you approach a case that sought to limit or overturn the central holding in New York Times v. Sullivan?
Thank you, Senator. Anytime the court is asked to revisit a precedent, there are criteria that the court uses to decide whether or not to overrule a precedent. New York Times versus Sullivan is a precedent, and stare decisis is very important. The principle that the Supreme Court should maintain its precedents for predictability and stability in the law. If the court is asked to revisit a precedent, its criteria, what it looks at, whether the precedent is wrong, and in fact egregiously wrong, the court has said, whether there's been reliance on that precedent, whether there are other cases that are similar to the precedent or that relied on the precedent that have now shifted so that the precedent is no longer on firm footing, whether or not the precedent is workable. Sometimes the Supreme Court will issue a ruling and determine later that it's not actually doing what the court intended, and whether or not there are new facts or a new understanding of the facts. Those various criteria are what the court looks at to decide whether or not to overturn a precedent, and they would be what I would look at if I were confirmed to the Supreme Court.
Thank you. I was recalling as you spoke about stare decisis at one of your first nominations hearing for the district court, and you actually, in response to one of my questions, you said stare decisis is a bedrock legal principle that ensures consistency and impartiality of judgments. And I think, as you know, by how you've talked more broadly about this, moving off of the First Amendment questions, throughout the court's history, stare decisis has been so key, and the court has relied on it to maintain stability in the law, reaffirm its impartiality. As a former justice, I know Senator Durbin just read a very famous book about him, Minnesotan, Justice Harry Blackmun, who actually Justice Breyer succeeded on the court, said in his concurrence in Planned Parenthood v. Casey about the court's decision to uphold Roe v. Wade, he said, "What has happened today should serve as a model for future justices and a warning to all who have tried to turn this court into yet another political branch." What role do you think that stare decisis plays in protecting the independence of the judiciary and avoiding the perception that the court is acting as another, quote, political branch?
I think it plays a very important role as a doctrine that keeps shifts from happening in the court. That, as I previously mentioned, it's very important to have stability in the law for rule of law purposes, so that people can order themselves and predict their lives given what the Supreme Court has already said. And if there were massive shifts every time a new justice came on, or every time new circumstances arose, there would be a concern that public confidence would be eroded. And so stare decisis is a very important doctrine that the Supreme Court has established, and it's one that furthers the rule of law in this country.
Thank you very much. Well, that's a good way to end Judge Jackson. And I do see Senator Cruz waiting in the wing. So by coincidence, and it looks like he has things he's putting up of charts. By coincidence, I was going to put on the record, and since he's here, it makes a lot of sense, from the judge that you clerked for, Senator Cruz, Judge Ludwig, who's now retired, and I know you were very close to him. And he actually submitted a letter on your behalf, Judge Jackson, and said in this letter, and he's an appointee of George H.W. Bush, similar to Judge Griffith, who introduced you yesterday, and I've been very impressed by the support you've had from retired judges, obviously not appropriate for current judges, but retired judges appointed by both Democratic and Republican presidents, as well as the bipartisan votes that you have gotten through the U.S. Senate for your other positions. But in this letter, the former Judge Ludwig says that you are eminently qualified to serve on the Supreme Court of the United States. And then he actually says Republicans and Democrats alike should give their studied advice and then their consent to the president's nomination. And he adds Republicans in particular should vote to confirm Judge Jackson. So I thought that might be a good segue Senator Cruz, to your question. So I asked Chairman that the letter of support from former Judge Luttig, who employed Senator Cruz as a trusted law clerk, be admitted to the record.
Without objection.
Thank you very much, Judge Jackson.
Thank you.
Senator Klobuchar finds a Minnesota connection to almost everything. Very proud of the fact, but Justice Blackmun was born in Nashville, Illinois.
Okay, he was a lawyer at the Mayo Clinic, as we know, and spent a lot of time.
I'm going to lose this battle.
A lawyer in Minnesota when he was chosen to the Supreme Court, but thank you for pointing that out.
And now to the great state, Judge Jackson, from 48 former federal prosecutors in South Florida. Without objection, Senator Klobuchar.
Thank you very much, Chairman Durbin. Welcome back, Judge Jackson. Yesterday, you and I discussed the court's increasing reliance on issuing unsigned orders on its shadow docket. And less than an hour ago, the court once again used the shadow docket to throw out Wisconsin's redistricting maps. And because this decision just came out, I don't expect you to have immediately reviewed it. But I just want to make this point that in her dissent, Justice Sotomayor, joined by Justice Kagan, called the court's move unprecedented. She noted that in an emergency posture, the court summarily overturns a Wisconsin Supreme Court decision resolving a conflict over the state's redistricting, a decision that was rendered after a 5-month process involving all interested stakeholders, based on an obligation that is, these are her words, hazy at best, even though summary reversals are generally reserved for decisions in violation of settled law. And again, I don't expect you to be familiar with this case, but I do want to point out that this underscores the point that I made yesterday, that the court's increasing practice of using the shadow docket to decide cases that have grave consequences for our democracy, including the right to vote, that you and many other nominees have said is fundamental, is incredibly troubling. You had in the other case I mentioned yesterday where Justice Roberts dissented, the Texas abortion bounty hunter case, that should not have been done on the shadow docket. And while I'm not going to ask you about this because you couldn't possibly have read it, just your record of writing decisions that are thorough and listening to litigants in cases, could you just generally talk about the importance of having full briefings on the merits as well as public oral arguments if you believe in transparency?
Thank you, Senator. As a judge in my work over the last decade, I've seen that it is very important, at least to me in my time as a judge up to date, to hear arguments from all sides in a case. The duty of a judge is to make determinations, and under our system of adversarial proceedings, you make determinations based on arguments, and it's important to do so. I know that with respect to the emergency docket, you haven't asked me the question about it, because I would say what I said before, which is I would benefit from being able to speak with the justices. I understand that there's a need to balance getting full briefing with emergency circumstances, and the court has long had in its procedures the ability to rule quickly on various cases. Mm-hmm. It's also my understanding from my time clerking on the court that the court does recognize the value of allowing things to what we call percolate, meaning lower courts to hear issues. And my understanding is that at least in some of the recent cases, the justices have had oral argument related to some emergency matters. But from my perspective as a judge in the work that I've been doing, I know that it's important to hear from the parties.
Another hallmark of your work has been taking complex issues and making them accessible to the public. So much so that I actually referred to one of your opinions from a debate stage in Los Angeles, saying, as a wise judge said, those were my words, I guess I was ahead of my time, the president is not king in America, the law is king. I paraphrased it. That was a written opinion that you wrote that was over 65 pages long, relied extensively on Supreme Court and circuit precedent. It was Committee on the Judiciary v. McGahn. And could you talk about really two things, the importance of having the law written in terms that are easy to understand by people, and then secondly, your opinion was actually a narrow one. It required Mr. McGahn to appear to testify, but that said he remained free to assert any legally applicable privilege in response to the questions asked. So what you did there was a narrow opinion. What role do you think that narrow rulings play in helping to maintain the legitimacy of the court? Why is it important to have plain language in orders?
Thank you, Senator. Well, I'll start with the second first. I think that, as we've been discussing, we have a rule of law in this country which requires a certain amount of predictability and stability in the law. If there are big shifts in terms of legal principles and doctrines and whatnot, it could lead to people not understanding that judges are ruling on legal principles. It could lead to undermining public confidence, thinking that judges are injecting their own policy preferences rather than following the law in terms of their rulings. And so to further predictability, stability, there are many doctrines in judicial practice. There's stare decisis, which is the principle that if something has already been decided, very similarly, you at least if it may be binding on you if you're a lower court, but at least you have to contend with it because that is the law that existed before you got the case, and you don't want to make a big shift. And then there's also the principle that the understanding that when you are announcing rulings, you are building on what exists before, and so you don't want to make a big shift if you don't have to, because if you can find a way to rule incrementally in a more narrow way, it keeps the law stable. Is a part of the proposition that I mentioned before. In McGahn, in particular, it was a case in which there was a precedent directly on point from my district. It was not binding on me, but the exact same set of circumstances and arguments had been presented to another judge in my district. I believe it was something like 10 years prior to my case. And so we had law that governed the circumstance, and I looked at that, determined it was persuasive, and that I should continue the principles that had been laid down by in the prior case. Also, in accordance with those principles, the prior judge and I made the determination that when the president claims absolute immunity, the argument was that the person who had been subpoenaed by the legislature, a former employee of the White House, could say that they had immunity of some sort. In other words, it could have invoke executive privilege in response to particular questions, but they couldn't say, I don't have to show up at all. And so the argument that was being made was when the House of Representatives issues a subpoena and says, show up on this day at this time to answer questions, does that person can that person just ignore and say, I have immunity, I don't have to follow the law, in other words, respond to the subpoena? Or do I have to show up and sit there and listen to the questions? And if there are things that I believe I can't answer because they're privileged, then you invoke the privilege. And the prior case had said in this narrow way, you have to show up. You don't necessarily have to give the information. That's determined on a question by question basis, but you have to show up. And that's what I held in that case as well. And it's important to be clear in your rulings so that people understand that judges are ruling consistent with the law and not their own personal views.
Right. And speaking of being clear and being careful in your rulings, some of my colleagues have, I think, given not a necessarily true view of your whole record, because when it comes to your rulings being upheld, the numbers show that out of over 550 cases, your district court cases, you were reversed less than 3% of the time. And in some of the instances, you were reversed only to have your decision later upheld. I noticed one case, Territory of Guam v. United States, in which you were initially reversed, but then a unanimous Supreme Court reversed that decision, then siding with you in an opinion written by Justice Thomas and aligned with your view. Do you want to quickly talk about that case?
Well, that case is kind of legally complicated. It was a CERCLA case, which is a Superfund cleanup kind of case where the country of Guam, which has a dump site on it that was used by both the citizens of Guam and the United States before the 1950s, when the United States was stationed there. Military operations happened out of Guam, and there was a lot of dumping into this site. And over time, the site got contaminated, and Guam was charged with having to clean it up, which is millions and millions of dollars. And there are statutes, very complicated statutes, about the circumstances under which you can seek contribution, under which a country like that can ask for the United States to pay some of that cost, or other countries to pay some of that cost. And that was sort of the nature of the dispute. And I did a statutory interpretation about whether or not Guam's action could proceed. The United States filed a motion to dismiss, saying that all of the technical requirements of the law weren't met and that the action had to be dismissed. And I denied the motion to dismiss after interpreting the statute, saying that the action could continue. The D.C. Circuit reversed my view, had a different reading of the statute, saying that the motion to dismiss should have been granted, and dismissed the case. And then it was appealed to the Supreme Court. And as you say, the Supreme Court reinstated the action, saying it could proceed.
Very good. Thank you. In 1972, in Brandsburg v. Hayes, a 5-4 court did not recognize the reporter's privilege in the context of criminal grand jury testimony. And I spoke with you earlier at length about Times v. Sullivan and First Amendment issues, so this will be my last question on this. Since the court's decision, my state, like many other states, enacted strong reporters' privilege laws to protect journalists from having to divulge unpublished materials, confidential sources. How would you approach balancing the need to protect journalists and the role they play in informing the public against the need for law enforcement officers to gather information?
I would apply the precedents of the Supreme Court in this area. It would depend on the circumstances. As I mentioned, press freedoms is one of the fundamental First Amendment rights. The court has a number of precedents in terms of expressive freedom, press freedom, and in every case, there will be a specific set of circumstances regarding an alleged violation of the right, and the court would need to look at the facts and circumstances, the prior precedent, in order to determine whether that particular regulation could be upheld.
Okay, thank you. This is my very last question, Chair, before all of us get to eat lunch, including you. And that is really the important role of dissenting opinions. Justice Ginsburg once said this. She said, "Dissents speak to a future age. It's not simply to say my colleagues are wrong and I would do it this way, but the greatest dissents do become court opinions, and gradually over time their views sometimes become the dominant view." When Justice Ginsburg's rabbi gave a eulogy at her memorial service here in the Capitol, and some of us were fortunate enough to be there. They said, "Justice Ginsburg's dissents were not cries of defeat. They were blueprints for the future." What do you think is the purpose of a dissent? And do you want to talk just a little bit about that, this idea that they can be blueprints for the future?
Thank you, Senator. On the Supreme Court, there are 9 justices, and in every case, they're all sitting together to hear the issues in a case. And one hopes, and it often happens, that the justices agree as to issues in cases. That I believe that the vast majority of cases that the justices hear are actually not, there is no dissent, that they agree to the outcome. But there are cases in which, after deliberation and collaboration and consideration, the justices may disagree about how the case should be resolved, and there's a mechanism for every justice to decide whether they're going to join others, either in the majority, whether they're going to write a separate opinion that might agree with the majority but wants to make a different point, or whether they want to dissent. And sometimes more than one justice might dissent or join a dissent. It's a way of expressing one's own view that may differ from your colleagues. And with respect to the point that you made, there are actually many justices in history who have used the dissent mechanism to discuss the law in ways that others find over time to be more persuasive. And so I'm thinking of the first Justice Harlan, who dissented famously in Plessy versus Ferguson. He dissented alone. All of the other justices agreed with the proposition of separate but equal, and he said no in a dissent. And his dissent, generations later, became, according to Justice Thurgood Marshall, became the blueprint for Justice Marshall to make arguments that